The next matter to come before us this morning is in re EL. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, then you let me know when you get started. I'm keeping the clock and will keep you apprised of the passage of time. The court has read the briefs and we are ready to proceed when you want.
Thank you, Your Honor. Attorney Greg Price on behalf of EL. If I could reserve 4 minutes, I'd appreciate it. Your Honor, we have 3 assignment errors before the court today. I think largely they subsume each other in the first 2, so if I could concentrate on those, I'd appreciate it. The facts of this case arise from a Kenmore High School football game. Towards the end of that game, the 2 teams became extremely chippy, and in fact, several fights broke out around the field at that time. There were several students that were arrested. There were several parents that were arrested. This is just one of many cases that landed in the Summit County Juvenile Court due to that incident. Our first and second assignments, Your Honor, are jurisdictional and a manifest way argument. And I think the court has to appreciate that in these situations with juvenile court delinquency cases, whenever you're talking about jurisdiction, sufficiency of the evidence, manifest way of the evidence, at a certain point, all those 3 things become one. The juvenile court has a specific jurisdictional standard which allows them to hear cases for delinquency of children that are under the age of 18. And that jurisdictional standard is both subject matter and it's personal. And I would agree with the state in this matter. I think this argument might be a little bit more personal, but I think it goes directly to subject matter as well. Whenever you start dealing with a child and you deal with a special situation such as delinquency, and a special court that's designed especially for that circumstance, you have to start requiring that the state provide at least any type of testimony that this child is under the age of 18.
What's the case law support for that?
And the case law, Your Honor, I think it's pretty sparse, to be completely honest. Whenever we're talking about personal and subject matter jurisdiction, everybody wants to espouse the fact, look, these are special cases, these are quasi-criminal, we've gotten to this point, but to be completely honest, whenever you're talking about something like this, you're talking about Civil Rule 12, and you start kind of parsing out Civil Rule 12, a lot of courts are saying, look, we're going to take this civil standard and place it in here, and say, look, if you don't bring up personal jurisdiction, you're going to waive.
Well, if we go back to the complaint, the complaint alleges that this is a child.
Correct.
And then if we look at the statute defines child as being under the age of 18.
Correct.
So hasn't the state established subject matter jurisdiction from the standpoint of this is a case that is supposed to be in the juvenile court?
And as far as subject matter, I think I would almost agree with the state at that point and say, well, if we're just going to do a cursory look at this complaint, is this a subject that should be in this court? I think we would have to look at that argument, to be completely honest. I would agree with the state that if you make those allegations, that's a subject matter. You're going to pass that jurisdictional question. The next question, do you have personal jurisdiction over this individual? And that's where I think this falls apart. And whenever you look, and even I think it kind of falls apart if you look at some of the legal precedent, if you go back, and I think in the state's brief, they point to Henry Burton. And I think that came out of the 6th District, about late 90s. That's where you get this rationale that, well, there is nothing that specifically addresses this in the juvenile rules, but what we're going to say is Civil Rule 12 directly addresses personal jurisdiction. And it says specifically, if you don't raise personal jurisdiction objection in your response to pleading, then you're going to waive it. Well, the concern that you have in juvenile court is, one, we've already said this is quasi-criminal. We're going to heighten the standards. We're going to kind of pull in some of the criminal standards sometimes. But at the same time, there is no response to pleadings. Whenever you have a civil case, you're dealing with a situation where I could say, Your Honor, you're going to sue me? That's fine. I don't want to have this suit heard in Summit County, but at the same time, I don't want to spend the time fighting. I'm just going to show up, I'm going to file my answer, we're going to get this thing done. Well, there's a reason for that, because I want to save money, because I don't want to drive to where it should be. Numerous reasons why I do that. However, if you read Henry Burton, it's very clear that I do that on a voluntary basis. If I show up, if I don't raise it, I voluntarily put myself within this court and put myself within this court's jurisdiction.
And none of those arguments regarding personal jurisdiction speak to the age at the time of the commission of the offense, correct?
Correct. And what they speak to is an adult making that decision. It doesn't speak to a child who's being forced, who's been arrested, showing up to this court and being told, look, you're going to show up and you're going to do this.
Well, so if they've established subject matter jurisdiction by virtue of the allegations in the complaint relating to the age of the child, what more do they have to do to establish personal jurisdiction in Summit County?
And personal jurisdiction would be, once again, it would be this person, its location, which is a venue argument, but it also has to be that this person's a child. And that's where you get this amalgamation of almost sufficiency of the evidence and manifest weight as well. Because if the state has to prove that this child is under the age of 18 to get personal jurisdiction, they also have to prove it for sufficiency of the evidence because you're alleging that this is a delinquent child who is under the age of 18. And it also goes to manifest weight because, once again, you have to be proving that this child is in fact a child as defined by the statute. So whenever you're talking about personal jurisdiction, yeah, location is one issue, but you still have to prove that this is a child that belongs in this court because you can't be filing a complaint for a 22-year-old that you can't, and you can keep him under pretrial supervision, you can keep him wherever you want to keep him until you have a hearing and the state has to prove his age. There has to be some kind of standard that says, look, in order for you to show that this is personal jurisdiction, you need to show this child's age. And it's very simple. They have access to all kinds of, they have birth certificates, school records, anything that shows that this child's 18.
Well, it's not the child's age at the time of the filing or the time of the trial, it's the child's age at the time of the commission of the offense, correct?
Correct. And once again, there could be a circumstance where you have a child that's 17 and they don't get tried till they're 22. And that's not what I'm addressing. What I would be addressing is someone that's 18 and they file a complaint in juvenile court, but then they don't have any recourse until we get to the trial because we say, look, if they say in the complaint that this is a child, that this person's under 18, that's all we need. There has to be some kind of standard to say, look, you also have to establish personal jurisdiction to prove that he is under 18 sometime before you get to a trial.
I guess my concern is that, we, among many, is that we always say that the assignment of error, in the brief is a roadmap, and we've been fairly consistent with holding counsel to the assignment of error. And so when we're reading the briefs, the assignment of error is that the trial court committed reversible error when it failed to grant the motion to dismiss for lack of subject matter jurisdiction. And that's what opposing counsel responded to. And it feels like now we're shifting and saying, well, maybe it's not for, subject matter jurisdiction. Maybe it's really, personal jurisdiction. But, we've got to respond to and decide what is set forth in the assignment of error. I'm not sure where that leaves us.
And where that leaves you, Your Honor, I think you can address the issue sua sponte since the state not only brought it up, but argued it rather extensively. And not only said, you know what, we're going to argue this point, but at the same time, they don't win on this point either. But once again, we're talking about jurisdictional issue. If this was something that was, I wanted to bring up a manifest argument that wasn't in there. It's not something, and I don't want to use the word trivial, but there are hierarchies whenever you come to appellate issues. I think when you get to the point of jurisdiction, and something comes up in argument, you say, look, there's a problem with jurisdiction. The opposing side has had an opportunity to argue that and has put forth a good argument. And I think they have case law to kind of support their side. I think the court can definitely take that up and say, look, this wasn't addressed, and I'll admit my assignment of error doesn't specifically address subject matter and personal jurisdiction, but both sides have adequately had time and notice and have argued that issue. And really, I think there needs to be some addressing this issue, because even when I did some research, tried to find something on personal jurisdiction. It's really, really, really hard to find something on juvenile delinquency cases because it's so easily subsumed with sufficiency and manifest arguments. There is nothing that specifically says, look, there's a personal jurisdiction issue in juvenile court, and this is how to handle it, except for In re Burton, which is a 99 case of a separate district that really doesn't go into the argument that much.
Well, one would think that if the state were required to establish age as an essential element of, finding an individual delinquent, that over the course of all this jurisprudence, there'd be some case out of some court that would say that, and apparently there is not.
And Your Honor, there's very little case law that even says the opposite. There's very little case law that says the court doesn't have to do that. I just think it's an issue that has not been addressed thoroughly. Because, and that goes into our second assignment, that the manifest weight so easily subsumes that and says, look, the state has to prove that this child is under the age of 18. They have to.
This is really not technical, but I'm curious. What is the dictionary definition of a child?
And to be completely honest, I don't know the Merriam-Webster definition. I just know the statute defined as
Okay.
anybody under 18.
So your position, if the common definition of child, let's say, is in Webster, is someone under the age of majority, that would be one way of describing it, assuming we all agree that the age of majority is 18. But you're saying in this case, we don't go anywhere else. We have to apply the statute.
Correct. If the statute's going to give us a definition, I can bring in Black's Law Dictionary, I can bring in Merriam-Webster, it doesn't matter, whatever the statute says. And in this case, whenever we're dealing with even the facts, even the record, there's absolutely nothing in the record to show that this child is under the age of 18.
And counsel, you have just under 4 minutes remaining.
Okay, if I could, I would like to reserve that 4 minutes, Your Honor.
Certainly.
Thank you.
May it please the court, Heaven DiMartino on behalf of Summit County Prosecutor's Office. We are asking this court to affirm the adjudication of Mr. Likely by delinquency by way of assault on a teacher. With regard to the appellant's first assignment of error, he does raise the assignment as a subject matter jurisdiction issue, and I believe he crafted it that way because subject matter jurisdiction is something that can't be waived, but personal jurisdiction can be waived. Clearly, juvenile court has exclusive jurisdiction over this matter as long as the person accused was a person under 18, a juvenile. The personal jurisdiction issue is not something that has to be proven at court if the complaint states that the juvenile is a child or a person under 18. The appellant could have filed a motion to dismiss based on personal jurisdiction, arguing that he was not under 18, therefore the court didn't have power over him, to issue a decision. However, once the court has subject matter jurisdiction, clearly the juvenile is under 18 and the court would have personal jurisdiction.
Well, let me just interrupt for a moment. Supposing the person is a student at a high school and the state believes, based on the information that they have received, that the person is a juvenile, files this complaint, but later it is discovered that there was some glitch with the birth certificate and the person really was 19 years old at the time. What happens to the court's jurisdiction?
At that point, the appellant would file a motion to dismiss based on the assertion that he's actually 19. The case would be dismissed and then it would be refiled at an adult court. So once the complaint was filed, this juvenile could have filed a motion to dismiss and correctly argued not subject matter but personal jurisdiction. But once that complaint was filed and no motion was filed arguing that he was underage, then it's waived. The issue of personal jurisdiction has been aged. And as the court pointed out, there is no case that says that in a juvenile delinquency matter, the state has the burden of proving age. Once the jurisdiction is invoked by filing a complaint, then the burden is on the defendant to say, actually, I'm 19 or I'm 20, therefore the court doesn't have jurisdiction. Because the court wouldn't have subject matter or personal jurisdiction over the juvenile if he was over age. And this There is some testimony, at least that lends some support to the fact that the juvenile was in fact a juvenile. This was a high school football game, it was a high school event. There were counselors that testified, coaches that testified. And appellant doesn't argue in any way, shape, or form that he was not a juvenile. He's just arguing that even though he filed a motion to dismiss based on subject matter jurisdiction and not personal jurisdiction, that somehow now that was an error on the part of the state. If he had filed a motion to dismiss in juvenile court after the complaint was filed and said, you don't have personal jurisdiction over me, I'm an adult, that motion would have been denied because the state would have introduced the evidence to show that he was actually a juvenile. But he didn't raise that below, so the state had no opportunity to respond to that. It's not an element of the offense that has to be proven for a delinquency case. The delinquency elements are the same as an adult element, the same crime if committed by an adult. It just happens at juvenile court. There's no requirement in the juvenile code that says, oh, in addition, you have to prove at trial before you can adjudicate delinquent by way of whatever the offense is, the specific age of the child at the time of the commission of the offense. So the state would argue that this court should address the assignment that was articulated in the brief, which was a challenge to subject matter jurisdiction. And the reason why the state responded to the argument and noted personal jurisdiction is because the state contends that this is truly a challenge to personal jurisdiction, but was crafted as a subject matter jurisdiction solely because that is something that cannot be waived. And I think that counsel would have to acknowledge that by not filing a motion to dismiss based on personal jurisdiction, not raising this issue at the trial court below, that it has been waived. And the fact that the only case on point is Burton, a case from the 90s out of the 6th district, does not in any way show that, in fact, personal jurisdiction cannot be waived. The only case that's on point is that particular case. There is no other case that the appellant can cite to in support of his argument. And again, I would ask that the court overrule his first assignment of error. If there are any other questions, I would respond to them. Otherwise, I would rest on the brief with regard to the second and third assignments of error.
Thank you.
Thank you, Your Honors.
Counsel, you have 3.5 minutes remaining.
Okay, perfect, thank you, Ron. And even if the court accepts the argument that the state is not obligated to prove personal jurisdiction, they still have an obligation to prove that this is a delinquent child. This is not a criminal trial where we're trying to show that this person is a thief, is a kidnapper, is a murderer, is a rapist. We're proving that this child is a delinquent child. They still have an obligation to prove age as an element. They have to show some kind of evidence to support that. And in this case, the only evidence you have is that this child is a senior at Kenmore High School that plays football. Nowhere else is age discussed. No evidence is entered. No exhibits are introduced to his age, period. So even if the court does not adopt my first assignment, the second assignment, I think it's very clear. There's zero evidence to support that he is a delinquent child. As to my third assignment of argument, Your Honor, ineffective assistance at trial, there were several instances where the trial counsel was both failing to object, failing to argue that certain pieces of evidence would be admitted. I would rest on my brief on those issues. The one issue that I'd like to bring up that I think there is no argument that he had a specific trial tactic is that he wanted to argue that EL had a concussion during a football game, that his behavior became erratic, that his behavior was easily diagnosable, and that he should have been assessed for a concussion. If you read the transcript of the proceedings, whenever we get to the chiropractor, the team physician, who I think is a chiropractor, he was cross-examined about his behavior, how the person can identify a concussion, what a person with a concussion acts like. Would EL's behavior be in the range of someone that has a concussion? But at the same time, he never did anything to get a medical diagnosis. He never did anything to get any kind of medical expert to that hearing. Because of that reason, there is absolutely no way that he had a specific trial tactic in mind by not getting that expert. If you're going to introduce that testimony, you have to get a medical expert to show whether or not this child had a concussion. And if this child had a concussion, that drastically changes his defenses to this claim.
Who called the chiropractor?
The chiropractor was called by the state, because the chiropractor is someone that went onto the field while the melee was going on and was trying to break up the fight. And specifically, there were several instances where the chiropractor was allowed to make hearsay statements about what EL's mother was saying, how EL's mother handled him, how that interaction worked. Trial counsel, once again, did nothing to object to those statements. And secondly, trial counsel, after the hearing with the magistrate, trial counsel withdrew. The public defender was appointed to handle the objection to the magistrate's decision. That magistrate's decision was filed late. The state actually moved to dismiss that. It was so late. The trial appellate counsel, I guess the objection, I guess we can call it that, at that point actually wrote something frantically. They wrote about a page-and-a-half statement saying the manifest wet did not support this. They put in half of that page-and-a-half was actually quotes from the transcript, so you really had very, very, very few words in that objection to the magistrate's decision. I think that's clearly going to be, once again, there's no trial tactic that would say, you know what, my best option at this point is to file this late, file it frantically, and put very little information into it. So for all these reasons, Your Honor, if the court doesn't have any more questions, we'd ask that this be remanded back to the Summit County Court. Or on the other hand, that if we find that there is no evidence at all of this child being 18, and that's therefore, we'd ask that it be dismissed. Thank you, Your Honors.
Thank you. Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides, as well as posted on our website and the Ohio Supreme Court website.
Thank you.